Welcome to IP Goes Pop, your source for exploring the interface between intellectual property and pop culture. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. This program should not be considered legal advice. Please consult an attorney for your specific situation. And now your host, intellectual property attorney, Michael Snyder.
Greetings and cheers and welcome to this episode of IP Goes Pop. I am your host, Michael Snyder with Volpe Koenig. This week, we're entering actually the world of sports as we explore a case called the Phillies versus ERICKSON Incorporated. First thing I would like to say thank you to the people at Good Day Philadelphia, the morning show at Fox 29, the amazing hosts Alex Holly and Mike Jerrick, always unbelievably prepared and interesting no matter what the topic. I was lucky enough to appear with them to discuss this issue twice, as it is of incredible importance to Philadelphia sports fans, of course, the beloved Phillies Phanatic, which we'll get to. And just wanted to give them a shout out, as well as a shout out to super planning manager Jody Harris. Thank you so much for getting Volpe Koenig involved in reviewing this interesting case, which again is of utmost importance to sports fans and really to people who just have any kind of relationship to Philadelphia sports in general, even if it's not baseball particularly. But who doesn't know the beloved Phillies Phanatic, the character that appeared on the scene back in 1978? So let's get into the case. And clearly this is an interface of popular culture and intellectual property, because the case turns on copyright laws and also has some trademark laws as well. So the case is about a company, Harrison-Erickson, and I'll tell you a little bit more about the background of that company. It's actually a really interesting company and very creative. They are trying to terminate rights in the Phillies Phanatic costume under the copyright laws, which we'll talk about whether the costume can be protected under the copyright laws. So what happened was that the Phillies brought an action to protect their rights for a declaration of their rights, what we in the law call a declaratory judgment. And again, as we review this, we're only going to go over the facts. We're not giving any legal opinions. I won't be giving any legal opinions or legal advice as a disclaimer. And again, our firm is not related to either the Phillies or Harrison-Erickson. So really reviewing this from an intellectual property standpoint, and also as a fan of sports in general, and also a fan of costumes, and a fan of the Muppets, if you will, or Jim Henson looking creations, which we'll talk about as well. So Harrison-Erickson is a company that claims certain rights in the original copyright of the Phillies Phanatic and the way that it looks. So the Phillies Phanatic costume. Now, according to the Phillies complaint back in 1978, Phillies executive vice president Bill Giles and the Phillies personnel worked with Harrison-Erickson to develop a costume for the Phanatic. And the costume was supposed to have a certain look and kind of a fun-loving feel to it. There were mentions, according to the complaint, of what color it should be. And this happened in around 1978. And there was an original agreement that was entered into around 1978 or 1979, which gave the Phillies some rights. Now, if you were watching sports during that time period, you will remember that the Phillies Phanatic absolutely hit the ground as a fan favorite immediately and became immediately associated with the Phillies and with the capering in the stands, and, beloved by young and old alike. I don't have any statistics on that, but we could probably run a poll, and I bet we could get at least one young person and one old person to say that they liked the Phanatic. So there you go. So according to the complaint, originally in 1984, Harrison-Erickson terminated or attempted to terminate the original 1979 license And ultimately, a settlement was negotiated. And according to this document, which I'll call the 1984 assignment, Harrison Erickson assigned all the rights to the Philly Phanatic, to the Phillies organization, quote unquote, forever. It's in the document. It says forever, and it was for about $215,000. Now, according to the complaint filed by the Phillies in June 1st, 2018, Harrison Erickson sent a letter to the Phillies giving notice of termination of any copyrights granted, basically threatening to make the Phanatic a free agent if they didn't renegotiate the 1984 assignment. Now, how can they do that? And I will take a time out here to discuss a little bit of the copyright law behind it. So in the Copyright Act, there's a section, which is section 17 U.S.C. section 203. We'll put that in the episode notes, that an author of a copyright can terminate rights that were previously granted according to a written agreement under certain conditions. Now, it is a complex area of copyright law, but generally, any time during a period of 5 years, so a 5-year window that begins at the end of 35 years from the date an agreement is executed, the author or the author's heirs and estates can terminate or cancel the prior copyright agreements. And if you think about this provision, where did it come from? Why do we have this kind of provision? So picture, a young singer going to a record label and saying, I'd really like a job. And they say, that's great. We'll sign you up for $500, a week. You'll write songs. And this is kind of an older Motown type situation, let's say, or another record company type situation. And, these songs become tremendous hits for millions of dollars. And perhaps after the passage of time, if they are still that popular and still have that much value, the original copyright owner, the person writing the songs, could terminate the original agreement, perhaps renegotiate and get more for their value. As far as copyright agreements go and how complicated they can be, even the Beatles are still involved in various negotiations and lawsuits. I would say the remaining Beatles and also the remaining record companies of the remaining Beatles are still involved in negotiations and contract disputes over publishing agreements in the area of copyright law. So these things, again, can go on for a very long time. If you think that, well, this was all settled in 1984, well, copyright matters tend to creep up again, if you will. So after the Phillies received this notice of termination letter, the Phillies say that, wait a second, we took that original this is the Phillies speaking. I'm speaking for them, but not really. The Phillies took the original 1978 character, and along with the actor inside the costume, they really expanded the character and the character's personality. And they actually have merchandise and trademark registrations for many different categories of goods. And even a trademark registration on the Philly Phanatic character. So on previous episodes of IP Goes Pop, we did talk about the interface of, overlapping patents and design patents and copyrights and trademarks. So here we have some of that issue cropping up again. So the Phillies complaint was filed on August 2nd, 2019, which we've been following the case for a while now. And they allege that a few things. One, they say Harrison Erickson doesn't have a right to terminate the 1984 assignment because they already terminated the 1979 agreement, and you can't just keep, for lack of a better word, you can't just keep canceling the agreements that you enter into. Another interesting part of what the Phillies allege in their complaint is they say that there is something wrong or an error in the original U.S. copyright for the Philly Phanatic costume as it was filed in the Copyright Office, because on the face page, so in any copyright application, they ask you what kind of work it is. And what it actually says on the form is nature of the work. Is this a script for a movie? Is this a painting? Is it a sculpture? Is it a text of a website? Is it computer software? There are many different things that you could fill in that form box of the Copyright Office. Of course, now it's all electronic. And then in the template form, you would fill out what is the nature of the work. Well, we'll post a copy of this with the episode notes, but in the nature of the work for the Philly Phanatic, for the original copyright filed, actually effective May 4th, 1979, it says artistic sculpture. And if you think to yourself, wait a second, is the Philly Phanatic costume, is that an artistic sculpture? I'm calling it a costume. It's a costume worn by a person. I'm sure if you put it on a stand or on a mannequin, it is a costume. And they attached to the original copyright application a photo of the Phanatic costume, which apparently is on a person or on a stand or perhaps on a mannequin. So it looks like a fully formed, if you will, sculpture. So that's the original copyright application. And the Phillies are saying, wait a second, that copyright application miscategorized the work. And for you, the listener of IP Goes Pop, it is an open question whether generally a costume, so a thing that you wear, for example, you go out on Halloween and you put on a unicorn outfit, for example. I'm making a lot of assumptions about the listener and their love of unicorns, but let's say you wear a unicorn outfit. Well, that's what copyright law calls a useful article. And a useful article cannot be covered by the copyright laws. It could be covered by other types of intellectual property laws. For example, you could have a trademark in the image of it, or you could have a design patent in the design of it, but you could not have a copyright registration that covers a useful article. Now, the law has expanded a little bit. There was a case actually in 2015, Star Athletica v. Varsity Brands, and it was a Sixth Circuit case, and then it went up to the Supreme Court, and the Supreme Court found that you could have designs as part of a uniform. So at issue in that case were cheerleading uniforms, and you could have a design of a uniform that was separable, if it was considered separable from the useful article itself. And this is what the Supreme Court said. They said an artistic feature of the design of a useful article is eligible for copyright protection if the feature can be perceived as a two-dimensional or three-dimensional work of art separate from the useful article and would qualify as a protectable pictorial, graphic, or sculptural work either on its own or in some other medium if imagined separately from the useful article. So then the question would be, is the Phanatic, is there some kind of design that could be protected separate from the costume itself? And that is something that the court, just a little background, the case of the Phillies complaint I'm talking about now is pending in the Southern District of New York, where there are a lot of copyright decisions and important copyright decisions come down because of the entertainment industry in New York. So that is one thing the court will have to look at. The other issue raised by the Phillies is that the Phillies have rights to what they call derivative works, which means a derivative work is a work based on or derived from one or more already existing works. And essentially the Phillies said, well, we took the original Philly Phanatic design, but we added a lot to it and we created new variations, and we have rights to those. And under the copyright, you can't terminate our rights to derivative works. Another thing that'll have to be decided by the court. Then the Phillies also said, I did mention it before, that they own some trademarks in the Phanatic, and those can never go back or be assigned to someone else. Now, to give some background, I've talked a lot about the Phillies. I do want to talk about Harrison Erickson, a really creative design firm that has developed and designed and put forth some amazing characters that we might all know or know people who know that are in the popular culture. For example, the Harrison Erickson firm created, well, I mean, I'm sure you know her, and if you know her, it's to know her is to love her, Miss Piggy character, which was one of the Muppets, part of the Jim Henson, workshops, and Statler and Waldorf, which were the two older gentlemen that stood, or not stood, but sat in the box during the Muppet Show and would mock the Muppet Show. And they worked as designers on Fraggle Rock, another Jim Henson related production. And They also have created several other mascots, which have a similar type of look in some cases. They did Big Shot for the 76ers, Ribby and Rhubarb for the Chicago White Sox, which I think were pretty short-lived. Stuff the Magic Dragon for the Orlando Magic certainly looks like a cousin or a relative of the Phanatic. We'll get into some others as we go on, but again, this is a costume design shop, let's say, for lack of a better word, that really has some pervasive popular culture characters that anyone would know. So they certainly had experience in this area, and that experience is likely why the Phillies originally went to them. We won't know. It will come out in the lawsuit, making some assumptions here again. We're not sure what's going to happen. And there are, outstanding attorneys on both sides of this case. So it is getting very interesting. One thing we should talk about is who is the author. So generally, copyright is owned by the author. It could be joint authors, two people that contribute to a copyrightable work. So if two authors work together, they both have rights in the work. They're considered joint copyright authors. Often, when two people are creating something, there can end up, I wouldn't say often, but there can end up being a dispute as to who owns what and who contributed what. And you could imagine, and on a future episode of IP Goes Pop, we are going to talk about disputes in the music industry. As you can imagine, I'm sure you read about them in the articles, fights over, how much of a contribution was made. And of course, there's a lot at stake here. There's, millions in royalties and publishing credits and writing credits. So there is a lot at stake. And there's a lot at stake, of course, here because the Phillies don't want to lose their mascot. So the Phillies, on the one hand, say that they contributed through their Phillies executive vice president, Bill Giles, back in 1978, that he provided some creative direction. And therefore, there is, at least some of an ownership issue in the Philly Phanatic costume. Now, part two, I would say, of this saga is that the Phillies actually unveiled a new Phanatic costume. And we'll talk about how new that was on Sunday, February 23rd, 2020 at Spectrum Field in Clearwater against the Pittsburgh Pirates. And it got a lot of attention, and they announced there is a new Philly Phanatic costume, slightly modified. And of course, I think it's a fair assumption to say that this is directly related to the lawsuit. And by the way, people were very concerned. I remember there was a news clip saying this would be revealed, kind of a teaser clip. And people were very concerned about, what the modified costume would look like. So I'll go over some changes. And in the show notes, we're going to post a couple links to the new, quote unquote, new look Phillies Phanatic. So what are the differences? Well, he definitely was slimmed down a bit. Definitely had a look that they were perhaps on a Peloton or some kind of boot camp regimen, but definitely a slimmer fighting weight Philly Phanatic. The color of green was slightly lighter. There was a different star-like design behind the eyes of the Phanatic. Those kind of, googly Muppet type or Jim Henson type eyes. There were bigger and bushier eyebrows. The eyebrows were a lighter color blue. There were now scales like a dragon under the arms. By the way, you really learn a lot about mascots when you dig into these things. The hands were now separate from the fur. So the original, let's say, or the older Phanatic before these changes had big kind of mitten-like hands. And here they had glove-like hands that were separate from the fur. I'm sure the person wearing the costume has a lot of more mobility that way. It was definitely a tighter fitting jersey, Phillies jersey on the Phanatic. There was a change to the sneakers. The sneakers used to have actual laces. Now they have no laces. There were blue socks instead of red socks. And there's a solid blue tail, which it used to be a green and blue tail. And I know these sound like small changes in some cases, big changes in another case. I think if you were to look at the Phillies Phanatic, you would certainly recognize it overall, but this has something to do with the lawsuit. There were definitely changes made, perhaps to make the Philly Phanatic costume match all of the contributions on the Philly side, so that they can, again, claim it was a derivative work and they have a right to keep using it. And again, the way that relates to the law, Copyright Act 17 U.S.C. 203, there's a statement in the law that says, a derivative work prepared under authority of the grant before its termination may continue to be utilized under the terms of the grant after its termination. So if the Phillies can somehow say that the costume was redesigned, was a derivative work, and they can keep using it, then perhaps, Harris and Erickson won't be able to terminate. Now, it's interesting, again, and when I began speaking about this, people did point out that a lot of similarities to a lot of other costumes, that they have this kind of look, again, with the googly eyes, with kind of the pear-shaped, big furry bodies, with the big floppy hands and the big floppy feet. And if there is a very close mascot out of Japan from the Hiroshima Toyo Carp. I hope I'm pronouncing everything correctly. And the name of that mascot is Slyly. And again, we will put up a picture in the show notes. It is very reminiscent of Slyly is very reminiscent of the Philly Phanatic. In fact, it has a snout like the Phanatic, has a uniform like the Phanatic, a pinstripe red uniform, says Carp. Of course, it doesn't say Phillies. It has the eyes. It has the big kind of flowery design or eyelashes behind the eyes. And as I said, they could certainly be, related or cousins, or if they were at the family barbecue, you would say, of course, they're related. This makes perfect sense. Stuff the Magic Dragon down in Orlando is definitely a second or third removed cousin. And again, it was created by the same design shop. So there is a look that you would go to the design shop for, and it certainly kind of pervades all of the different designs. So where we are today, I looked up the recent filings in the case, and the most recent filings are in July of 2020. And right now, the parties and with the court, are attempting to get an opinion from the Copyright Office regarding whether, in fact, the original copyright registration was valid and was it correctly submitted. There are ways to ask for an opinion from the Register of Copyrights as to whether, let's say that the original copyright application or the form filled out back in 1978 or 1979 said the nature of the work was a mascot costume. Would they have rejected it outright? And that is a question that they are trying to get answered in the case. And right now they are waiting to resolve how they will approach the Copyright Office to ask that question. So again, each side wants to word the question in certain ways. Each side is trying to have their facts presented. As I said before, it is certainly one to watch. There are interesting issues that are going to come out of it. For example, whether you could register a costume by having it displayed as a sculpture and then claim it as a sculpture in the Copyright Act, whether the Phillies have changed or created a derivative work that would now, they can keep the rights in, even if they terminate the original rights in the original looking Phanatic. But as a fan, if you watched the news or saw any of the news surrounding this particular change or even this dispute, you would have noticed people don't, people don't like change in general, and they certainly don't like change surrounding their sports. If anyone lived through a logo change of their sports team, or anyone lived through a color change of the uniforms of their sports team, or if there's any sports fans that are part of an expansion team, the selection of the name of the new sports team, any of those things that occurred, people are resistant to change, but certainly don't want to lose a character that was associated with, in this case, when you think of the Phillies championships that took place, the Phanatic was there. and you certainly wouldn't want to lose that goodwill surrounding it. Now, we are going in a later episode of IP Goes Pop, we are going to talk about action figures and the protection of action figures. And, they're, of course, in the popular culture. I mean, movies joke about the collection of action figures, and they've gotten better and better. You'll hear us talk about that as well. Just another upcoming episode teaser, we're going to be talking about Marvel and DC characters, ones that seem very similar to the point where it's hard to believe that they coexist without a fight. We'll also talk about Stan Lee and his contribution, again, not only to the comic world, but popular culture in general. And also some IP ownership issues with the characters that he created and some disputes about the characters he created as well. So, as always, this is Michael Snyder of Volpe Koenig with IP Goes Pop. Wishing you a wonderful 2 weeks till our next episode. Stay safe, be well, cheers. We will see you on the airwaves soon.
The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com.